The Constitutional Court will have the final say on a section of South Africa's Recognition of Customary Marriages Act that lower courts have found to be unlawful. It allows couples in monogamous customary marriages to convert their marriage into a civil one, which critics say bypasses divorce laws. Let's get you some analysis now with Sibongile Ndashe. She's the Executive Director, of the Initiative for Strategic Litigation in Africa. Sibongile, thanks very much indeed for your time. So I've been reading through some of the issues surrounding prenups and customary marriages. If there is no prenup entered into before customary marriage, what the court does sort of default to is community of property, right?
That is correct, yes. That's the regime that applies in the absence of the antenuptial contract.
And how does that complicate things for couples?
With the recognition of customary marriages, we have to go back to that under apartheid South Africa, customary marriages were not recognized. So what happens was people will enter into a customary marriage, but this would not be called a marriage, legally. So, and then they will celebrate, but then for it to be legally recognized, then they will have to go and get married civilly. This position changed in 1998 when the recognition of customary law was adopted. And so what we saw here was with the coming into effect of the recognition of customary marriages, it said this is a marriage. So even if you proceed to go and get married under civil law, the customary marriage that you have entered into through the negotiation of lobola, the handing over of the bride, and other practices, and this differs, from for people in different cultures. So what's been happening, though, is that many people still continue to have these double marriages, like have a customary marriage and then later on have a civil marriage. But what happens here with this provision is that here the parties kind of tried to comply, but the compliance actually was not useful. This article that's under interrogation 10.2 says you can change your marital regime from customary, which is in community of property, the default, into any other kind of proprietary regime. But you can do so by agreement. Now, when marriages are ended, typically parties go to the High Court because this is a status issue. So the High Courts are the ones that deals with these kind of cases. But the customary marriage legislation basically says you can end a marriage without actually having resorted to the High Court. And this causes challenges for the parties, normally the one that's financially weaker, and in most of the instances, those are women. Because it does not dissolve the community of property, which default is 50-50, it simply says that we have now changed, this marriage. So what happens here is this: the parties entered into this antenuptial contract, which is by accrual, which simply says that what you brought into the marriage becomes yours, but what accrued to you during the course of the marriage is divided between both parties. So here, what's being challenged is that this is unfair. Here's someone who started the marriage with a 50-50 regime, which by agreement, which is not censored by the court, approved by the court, suddenly finds themselves with almost nothing at the end of the marriage, because the proprietary regime was dissolved, but was changed. The proprietary regime is changed, but she doesn't get the 50% that she would have been entitled to first, under the in-community of property. So here the challenge is a very simple one before the court to say that it is discriminatory against parties who are married under customary law, because people who are married civilly will have the protection of the court. There is a provision in the Marriage Act that allows people to change their proprietary regime, but you don't just sign a contract. The courts have to approve that. And so that's what's being sought in this case.
Right. So, I mean, if a customary marriage is recognized, as it has been for some time now, it makes sense then that only a court of law can dissolve a marriage through divorce, whether it's a customary marriage or a civil union.
Correctly, because this is a status issue. So there are quite a number of things that need to change. You know, before the coming into effect of the customary marriages, we had kind of traditional courts dissolving marriages. And I remember in the early 2000s, shortly after this legislation came into effect, and I was still a lawyer then at the Women's Legal Center, we used to engage, you know, with traditional authorities who were still dissolving marriages to say that you no longer have the power to dissolve through the high courts. And so here the problem is simply that this was contained in the legislation. But the customary marriages legislation, when you look at it, actually has been to the Constitutional Court a number of times to continue changing, you know, some of the things that remained unclear. So it does look like in the framework, when the legislation was developed, there were concessions that were made, but right now it's becoming clear that these concessions no longer hold because there is a legal gap that is being exposed.
Right. So, Sibongile, we're running a bit out of time, and there are a couple of questions I still want to ask you. When traditional leaders were dissolving customary marriages, the cases that you just mentioned, how would that have impacted the division of assets?
So some of it was quite unfair because what they are looking at is not what the courts kind of look into it. So you would find that women would be punished, you know, because they are looking at the conduct or the behavior, you know, of the person. So it's sometimes kind of fault-based. The woman cheated, so she was a bad woman, so she's not entitled to that. Our civil courts don't do that, you know. It's a no fault. They are looking at the proprietary regime, what's in the best interest of the child.
They're just looking at the contract.
Yes.
Yeah, yeah. So is one of the, not solutions, but a way of mitigating this, that customary marriages be registered then at the Department of Home Affairs? And is that something that couples do in a customary marriage just by default?
It is something that needs to happen. The legislation provides for that. You can go and register a customary marriage. But what the South African legislation does not do, and it does not say that just because your marriage is not registered that it is invalid. So since this legislation was passed, what we see is that the Department of Justice keeps on extending, you know, the deadline for registration of marriages. And this is an important thing in the South African legislation because in other countries, marriages that are not registered are not recognized. Mm-hmm. What is important here is that when we understand how customary marriages are entered into, here when you get married in church, then there's the presiding officer, and then the register is sent to kind of Home Affairs, you know, and if you get married at Home Affairs, then that's what happens. But in customary marriages here, we're normally talking about families. There's no presiding officers, you know, there's a letter. It's a whole process, you know, so sometimes there's even questions about when do you say it has been validly concluded. Mm-hmm. You know, it's not like the first day. There are many factors that are looked into. So we don't want to penalize, you know, people who entered into customary marriages by treating them like this is a deadline, you got married here and then you should have registered here. And there's also a lack of legal empowerment for many people who find themselves, you know, in this position. So many people still do not know that customary marriages, you know, are binding marriages. Mm. And that's why they continue to conclude a civil marriage and treat it like it's a first marriage. And then they find out that actually you were married and what's applicable is the first proprietary regime. So the registration is important, but we need to go out there and actually tell people to register their marriages because this does become a problem at some point.
Yeah, so it sounds like, Sibongile, and the Constitutional Court is usually very punctual. It's meant to sit at 10 o'clock to decide on the validity of antenuptial contracts following customary marriages. But in your experience, Sibongile, is it a case as well of just education, of just knowing what it is that you are getting into, what your rights are?
That is important, but I think it's also important to understand how the limits of the law here itself, because here we have got a law that is about 26 years, in existence, but still many people do not understand, because there is a way to understand marriage kind of culturally, and then there is a way to understand it in terms of the law that has been passed by Parliament. And part of what we need to do is to try and marry these two, because there are quite a number of people. We actually saw it even now, after the death of the former Deputy President, David Mabuza. The issue that's been taken there in court is you have someone who is saying, although the media has been referring to me, as a former fiancé, I'm actually a customary law wife, because, we concluded, a marriage. And then that's the question that has to. So there are people who may be walking around thinking that they are not married, but there is a possibility that they may be married.
So there's one case that I've been reading up on, just in terms of the various legal complexities around customary versus civil marriages. And Sibongile, just for clarity, you mentioned earlier that some people enter into a customary marriage and then they also conduct a civil union. They also enter into a civil marriage. These two marriages, can they coexist? I mean, as you say, if you are married under customary law, you are legally married. And that was the case of one husband and wife. The wife told the High Court in Polokwane that they were married under customary law and therefore community of property applied. But then the husband said, no, they had a civil ceremony and they have a prenuptial agreement.
Yeah, so the courts have been coming back saying the first marriage, the proprietary regime of the first marriage, is that what is valid. So if people do not wish to enter into a marriage in community of property, which is the default system, before the uncles are sent to start negotiating the lobola, they must enter into an antenuptial contract then, because what happens afterwards, it's in community of property.
And it's important that these agreements are entered into before the marriage. I see that the Constitutional Court is now sitting, Sibongile Ndashe. Let me thank you for your time, take you live to the Apex Court as it now considers the case of the validity of antenuptial contracts